Let's go to the name. Yes. And I believe, okay, yeah.
Yes.
And I think Melissa is doing this. We got, is everyone ready? Okay. Thank you.
Thank you. Melissa Langbacher for the record, morning chair and police policy committee members. The department opened a professional standards case for Almadina Yavor based on a separation from employment from the Columbia River Police Department. The agency reported that Yavor's resignation during an investigation into allegations that she was in a romantic relationship with a known felon offender. An investigation into the allegations was conducted and there were sustained findings that Yavor violated the agency's policies, finding that the community was aware she was having a relationship with a known offender, which was harming the standing of the agency in the community. Her 20+ meetings with him on non-official business equated to not performing the duties of her position in an efficient manner. Her use of law enforcement data systems for personal reasons threatened the agency's access to the information system. The department found that she violated the standard for misuse of authority by running the license plate of the vehicle owned by her romantic partner after she was questioned about her relationship with them. Yavor misused her position to intentionally retrieve information from the law enforcement data systems for her benefit. For misconduct, Yavor's romantic relationship with the known offender threatened or harmed the efficient operations of the Columbia River Tribal Police Department. Her romantic relationship damaged the standing and trust within the community. Her utilizing of agency's time set aside for her to conduct patrols to foster a romantic relationship. She neglected her duties to foster that relationship, which impacted the morale of the officers who were performing their duties efficiently. Her misuse of the law enforcement data system to look up information on the known offender threatened the agency's access to the system, which could diminish their day-to-day operations of the agency, that they were sanctioned. Were they to be sanctioned for her actions? The department is seeking a vote to affirm, modify, or negate the findings. And Ms. Yavor is here remotely to provide a verbal statement to the committee.
Melissa. Ms. Yavor, can you hear me?
Yes.
Thank you. My name is Scotty Nowning. I'm the chair of the police policy committee. Now's the time for your mitigation. You will be given 5 minutes and 5 minutes only to provide a statement to the committee. How would you like me to let you know when you have about 30 seconds to go?
You can just, yeah, you could just let me know when I got 30 seconds.
Okay, and you can pick a time if you'd like a minute. It's up to you, really.
Yeah, maybe it won't take the whole 5 minutes.
Okay, I appreciate it, and I will let you know when you have about 30 seconds to go, and we will stop you at 5 minutes. After the completion of that, you won't be able to ask us questions, and we won't be able to ask you questions. You're welcome to stay online and listen to the rest of the conversation about your case.
Okay.
And whenever you're ready, we're ready.
Yeah, so I did begin a relationship with a person with a criminal record, unbeknownst to me that it was against department policy. I got hired with Columbia River Intertribal Police Department when I was, I believe, 23 or approaching 23. And I was a naive and young officer. Those 20+ meetings with him, though, that was due to me patrolling the in lieu sites that he was fishing on. And it wasn't just with him that I conversed. It was with members of the community. You know, I spent time on the in lieu sites speaking to the community members a lot, not just running from in lieu site to in lieu site. I actually spent time on the sites. Yes, I did begin a relationship with him, and I did not disclose it due to my own naivety, I guess you could call it. But I was never once dishonest. I never lied, cheated, or stole anything of that nature. I began a relationship with a person with a record, and we all have pasts. I guess the accusation of me running his license plate, yes, I ran almost every license plate that was on the in lieu sites that was within my scope of duties. I ran him before we got into a relationship. I ran almost everybody that I came in contact with. That's just a basic officer safety concern for me. That's all I have to say for now.
Okay, thank you. I appreciate it. Okay, now we need to have a consensus to adopt the record or return the record for more information. Getting a consensus in the room, any objections online or otherwise? Hearing none. We'll adopt the record as is presented. We'll now open up for aggravating and mitigating factors. Reminder to state your name and whether or not it's an aggravating or mitigating factor.
Member Townsend, aggravating. My concern is that this was reported by a member of the community, a tribal member of the community, and that the relationship may not have been disclosed or discovered, had not been brought forward by that member of the community. And so I'm concerned that this may not have come to light had that not occurred.
Thank you.
Michelle Duncan for the record. In reading this, her agency even gave her the opportunity to discontinue the relationship, even though she stated she didn't know it was a policy violation. She was notified at that time at least, and still chose to continue the relationship with this person.
For the record, aggravating that she did appear to use our systems for personal gain of knowledge. But mitigating would be that does not appear to be a pattern of it. It might have been a one-off. Two, to her verbal testimony that she then also ran him specifically.
Sheriff Bradler for the record, in alignment with that. The record states in conflict with what she testified to, that she had ran the plate before their relationship, if that's what I heard correctly. The record here says that after the relationship began, that the license plate was run on February 14th of 2023. After she had been questioned about the suspicion of violating the relationship policy. So there's some conflict there in the mitigating testimony today.
Thank you. Scotty, now for the record, aggravating as well as our testimony. I believe the car, according to our record, the car was registered at her residence. So when she ran it. So it would have been after they were certainly in a relationship.
There, for the record, this just kind of is a food for thought conversation. Everybody gets into law enforcement, I think gets into it for certain reasons, and we know what our ultimate goal is to keep people safe. But whether it's an activity or you read the policy and you know it, affiliating yourself with felons should be something that should be at least pop onto your radar as is not allowed, or to at least then start asking some questions. So I think I find that a little bit aggravating with the verbal explanation.
Data on the record, I also under aggravation. I think it's clear that, she has attended DPSST, she went through the basic police academy. There's discussion about who you should and who you shouldn't be around in the basic academy, and certainly going through APTAP. Officer safety, establishing those relationships and how those can compromise. Not to mention the fact that the agency is a Lexipol agency and it has a policy that specifically outlines this conduct. Number two, that she would have read that policy and acknowledged that in the Lexipol policy system.
Anything else aggravating, mitigating? All right.
Mr. Chair, I have, one mitigating, factor, which was that her, use of systems for her personal benefit did not appear to be a pattern. And for aggravating, that her, relationship was reported by a member of the community, and had, that member not reported it, her relationship may never have come to light. The agency gave her, the option to continue, her employment and the relationship, with the known offender, and she chose to continue the relationship. It did not. She did appear to use the systems, for her benefits, and she ran, his information specifically. Records indicate that after she began, the relationship with the offender, she ran, his license plate. The car at the time was registered, at her residence, and would have been after their relationship began. Affiliating with known felon should be something that officers question about themselves and their what they're doing in law enforcement. She attended the Academy of Officer Safety courses, and it would have been something that was covered in those policy that she read, and would have been required to acknowledge that her relationship needed to be disclosed. Mr. Chair.
Looking for a consensus that this has captured or aggravating and mitigated. Any objections? Thank you, Melissa. We're now open discussion about whether there was a moral fitness violation. You need to affirm, modify, or negate. And in this case, it is misuse of authority and misconduct, which the department has identified. We'll be looking for a motion on that.
And Chair, Captain Calvin, for the record, that would be 3 to 10 years for either one of those, your range.
Thank you.
For the record, I make a motion, on both misuse of authority and misconduct.
And I will second.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Narani?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wolf?
Aye.
Motion passed.
We will now look for a recommendation on to take action or not. And will the motion to take action or to not take action? Discuss or someone to make a motion
Member Townsend, I'll motion.
to take action? Sharon, I'll second.
Voting on a motion to take action. Chair Narani?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren? Committee Member Townsend? And Committee Member Wood? Motion passed.
We'll now have discussion and motion regarding the amount of ineligibility period. And as Captain McAlpine stated, 3 to 10 years, is that what we're looking at?
That's correct, Chair.
And apparently it would start from separation of employment February 22nd of 2023. If you make a recommendation and we call for a motion, please state what your recommendation is and justify why you're picking that amount of time.
Michelle Duncan, for the record, I'd make a recommendation for 10 years for each violation. Partly because of her statement here today. She, I don't feel, was taking full responsibility. Even though she could have, this would have been her opportunity. you know, she was given, now this is the third opportunity in my mind to take full responsibility for her conduct that could not only compromise safety of others, deputies, officers, whatever, out on the street, but also just the public trust, and that kind of thing.
Townsend, I would support what the sheriff just had to say, time limit. I'm not convinced by, especially by her testimony today, the comment that she ran everyone in the community. I'm not convinced that if she were to have access to databases in the future, that, inquiries on those systems would be just for criminal justice purposes only. So I will support the sheriff had to say.
Chair Nine, for the record, I was leaning toward much less time because of her small amount of time in the career field, and it seemed to be a one-off. But to echo what you said during her own testimony today, she still hadn't taken responsibility for what she did. And, you know, looking at her training record, she had been trained in LEDs multiple times, and it's a very core function of LEDs, and a very well understood that we just can't do that. So I would agree with everything's been said.
It didn't click to me until I think Sheriff Hackenberg said it. If that car was in fact registered to her at her house, she would have known that. She wouldn't have needed to run the plate so close after her interviews and then before leaving. Which is a clear and just clear misuse of that system 100%. So that didn't click. So I have to agree.
Probably for the record, I put less weight on the list violation, maybe because I don't understand. If I understood what she ran the plate for registered owner, but did she run the registered owner? Was she looking to verify that in fact it was registered now at her home address? Or was she running the person she was having the relationship with? So I put less weight on that, and I was leaning towards what our chairman said, less time, but I also agree with you with their testimony today, actually added to an aggravating situation, not taking responsibility for it, as you mentioned, the third time.
Barrett, for the record, when those systems can get audited, if you've got one bad actor using it in your department for not lawful purposes, the entire agency can lose access to that search. So that's where it's a compounding problem, and it's going to cause a much larger issue for the agency to do their job if they don't have access to it. So I think that's why we're all,
And Michelle Duncan, for the record, for me, I mean, there is some weight put on to the LEDS violation, but it's her testimony today of when and why she ran it. That is why I think this is a more egregious time, or more serious time that we should be imposing. Because as Sheriff Granberg pointed out, she's saying that she just runs everybody, although she was clearly already told about this relationship before she ran it. So yes, the LEDS is an issue, and it is an issue for the agency, but I think what I feel is the dishonesty in her testimony is more the factor that I'm considering.
Patty Lofgren, public member. For the record, just a clarification question, Sheriff Duncan, when you said 10 years per violation, does that mean 20 years?
Yes, I think unless it's I don't know if it's concurrent.
Catherine McCaffrey, for the record, our max is 10 years period.
Okay, 10 years. Thank you.
We have a motion and a second.
Yeah.
I know, yes, I'm sorry. Yeah, we appreciate all the discussion.
So we are voting on a motion for a 10-year ineligibility period. Chair Nowling?
Aye.
Vice Chair Conning?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lawford? Aye. Committee Member Townsend? Aye. Committee Member Wood? Motion passed.
Now we just write down the part.
Moving on, Randy Clark. Mr. Moore, you're free to go if you would like. Deborah, sing right. Almeida,
Yes, thank you. I would like to say I did take responsibility and I do take responsibility for my actions in this case. I don't know how it came across that I wasn't taking.
okay, our next case, Randy Clark. Listen again, thank you.
Thank you, Mr. Chair. Melissa Langbach for the record, policy committee members, the department opened a professional standards case for Randy Clark based on his separation from the Central Point Police Department. The agency reported that Clark retired during an investigation into allegations that he was continuing to contact his former girlfriend after repeated requests to cease contact. An investigation into the allegations was conducted and there were sustained findings that Clark failed to follow a lawful order to stop communicating with his former girlfriend. Clark gave misleading statements that misrepresented or omitted material information during the investigation into his conduct. Clark made statements to coworkers and subordinates that were misleading or disparaging that disrupted the efficient operations and good order of the department. Clark continually attempted to contact his former girlfriend after being told not to contact. Clark exhibited alarming and impulsive behavior in his repeated contact with her. And Clark utilized his department issued phone to attempt to contact his former girlfriend after being told not to contact. The department found after reviewing the information that Clark violated the board's moral fitness standards for dishonesty, misuse of authority, and misconduct. Finding Clark intentionally gave misleading statements during his interview during the internal investigation. For misuse of authority, Clark used his department issued phone for his benefit to attempt to contact his former girlfriend on several occasions. And for misconduct, Clark harmed the efficient operations of the Central Point Police Department by negatively impacting the morale and good order of the agency by telling coworkers while he was on administrative leave that he was being treated unfairly. Clark harmed another person by making repeated attempts to contact them when they wished not to communicate with them. Clark's appearance at his former girlfriend's place of employment harmed the efficient operations of her place of employment and made her coworkers feel uncomfortable. The department is seeking a vote to affirm modify your for Nikki.
You're looking for a consensus to adopt the record or to return this to the case staff for additional information? In the room, we have a consensus. Any objections? Seeing none, adopt the record. Now open the discussion for aggravating and mitigating factors. Reminder to state your name and whether or not your factors are aggravating or mitigating.
Kevin Dresser for the record. Jump up and correct me if I'm wrong. Some of the mitigating things is some lacking of detail in the totality of the investigation. When we talk about disparaging comments made to the subordinate coworkers, it's not other than unfairly thing. It's not specific. They can go back and interview specific members to say what those conversations or specific comments were. That sort of bothered me. Obviously, the former girlfriend not wanting to participate with the criminal investigation. Another point that I noted was that it was described as making a scene at her place of employment, but that wasn't really described other than the word scene, and there was actual specific sentence that said Clark was not belligerent or confrontational, and he was there for 5 minutes and apologized and left. There's just different things in here that just lacked a lot of detail and a lot of inferences without supporting detail to some of these statements.
Thank you. It's coming down to the record. I would say mitigating as well is, the girlfriend even admitted they've been together for 10 years and this had happened off and on where they had broke up and then they get back together and it seemed like one of those relationships that's maybe, well, I don't know why this time was the final time, but, she said she's not worried for her safety in any way. He's not violent. She didn't want to pursue criminal charges. I found it interesting, her route, and I do understand there's a lot of dynamics of domestic violence relationships, but I just we don't have that information in this record. And so for her to take this route of having the police department give a lawful order to not have contact with folks, is a very interesting route. And the court system is set up specifically for these type of cases, and she chose not to take that route. And so I think if she would have filed a stalking order or if she would have wanted to pursue criminal charges or anything like that, and this would have been a violation of that, it would hold a lot more weight. But in the police department getting involved in personal relationships, I'm just not even sure where that line is, okay.
Michelle Duncan, for the record, I kind of had some of the same concerns of like, can they even as an employer intercede in their personal life when it's, at least at this point, not a criminal matter, and then rely their termination on that order. I just felt like they chose the wrong lane in how to handle this conduct. And I don't know that I found anything that rose to the level that they described.
Sheriff Branford, for the record.
No.
I think that the agency can restrict behavior of folks, and I think it's upon us as leaders of agencies that when there are investigations going on, and folks are, particularly in domestic violence relationships where it is messy, and we put the onus on folks who are the subject, the victims of domestic violence, to do certain things. That myself as an employer, if I have someone coming to me and they're exhibiting concerning behavior that they refer to another police agency to do an investigation into potential criminal conduct, which is stalking, that we have every right to restrict their behavior, the employee, during that time. So once that is done, I think that it's difficult for us to govern behavior of folks, but certainly during this time, I think it's appropriate.
Robert, for the record, that's exactly where I was going. And she felt it urgent enough to purchase a product, purchase a home without letting him know. So there was something going on there that she didn't follow the route through the courts, which would have taken a long time. She took a shortcut and said, let's stop this immediately and contact your employer. Whether it's corrupt or not, I don't know, but I think in her state of mind, this is what I'm guessing, she took that route.
Kevin Dresser, for the record, I don't like guessing, I like details. We did an investigation, they could have done that, they allude to this EV history, but we have no information on it at all. So that's my problem, is they allude to many things, but they don't have any support for it in their investigation, at least the materials presented to us.
For the record, I would agree with that. So if we took the guessing component for the DV off the plate and just focused on the stalking, I'd say that we definitely have multiple stalking-like behaviors, not just one, but a couple occurrences, phone calls, blocking one phone. So he starts dialing from another. In a meeting with his chief and two captains, he was actually told that his behavior met the definition of stalking. So to Sheriff Brandenburg, that might have been their cue to get another agency involved, because also was domestic violence. Victims don't have to cooperate. They don't have to be participatory. That's when us as law enforcement are supposed to step in and protect these people. So yes, there's some guessing, but if I wanted to take that out, it looks like stalking, and that is, I think, in my opinion, that is here.
Sheriff Brandenburg, I agree with what you said. And the burden on the employer is preponderance of the evidence, not beyond a reasonable doubt, which is what courts use. So had this case gone to the courts and, they have to prove beyond reasonable doubt that this, as an employer, is preponderance of the evidence, which is 50% plus a feather.
Livingston, for the record, aggravating for me was just that he's a 30-year law enforcement officer.
and knows what stalking is, and that he can't accept or understand that his behaviors were going down that path, and he just kept using the excuses, we're just trying to work out our relationship. And it was clear that it was over. And regardless of the fact that, yes, they'd kind of gone back and forth, she took these extra steps. He should have clearly known this was over and him not. And he kind of alluded like he didn't know what that meant. And 30 years in law enforcement, you know what it means.
I love him for the record. Aggravating to me, it seemed like when he crossed the line was when he used the police issued phone to contact her because she was clearly establishing no contact issues. And so to me, that was where it kind of went on.
It's got it down for the record, and I think again, it's, agencies have different policies on calling your spouse or your work phone. And I think, it's probably very common that folks call their spouse or their loved ones with their work phone to say, I'm gonna be late, or I'm gonna do this, or I'm gonna do that. So, like I said, I just, what I find in this case, I need a lot more information. I need a lot more information. There's a typical stalking behavior is a lot of contact in a pretty short period of time. The person's, especially when they know this person, they know their routine. This is actually taking place over, it seems like a month, where it's, days in between the person showing up. And I just don't know enough about their relationship. I don't, I'm just listening to what she's telling the investigator. And to your point of she bought a car and a house, you can get a stalking order. The police officer can issue a stalking citation today. Someone comes in and says, I'm being stalked, and gives you evidence of that, and they want to pursue that, I can issue a stalking citation today. You issue a court date and a court will hear it. It's not a long process because stalking is dangerous, and we know that. So, the fact that she didn't not want to go through that, in fact, she said, I want him to keep his job. I think he's a good police officer. I just want him to be happy. It's just difficult because there's so much information I don't know, and we're having to kind of fill in the blanks.
Michelle Duncan for the record, I think additionally, she made a statement that she was not afraid of him harming her. She just wanted the relationship to be over. And just clarifying on the timeline, she came in 4 days after she moved out saying, hey, I don't want any contact with him, to his agency. They then issued the order. I feel like they should have, if they felt like it was a stalking issue, then, and I don't know that it would have risen to that level at that time, that now giving him an order to not talk to a girlfriend, that he has worked out things, like I'm trying to like give some mitigation to his mindset at the time. And then it was a week, 3 weeks later that it was finally given to Medford. I think it should have been, if that's what the agency's mindset was, they should have turned it over to another agency criminal right there. I just think that was the more correct path.
Oscar, for the record, I'm now going to backtrack to what Officer Dresser said, because based on what I've now reread, it's possible that he was using a phone number that she knew. I was thinking it was a phone number that she was not aware of, but so now it's unclear whether he was calling her with a number that she would have recognized total to work on. So I'm backtracking and saying, as Officer Dresser said, not enough information.
Any more? We're kind of back when we started. So, any more aggravating or mitigating factors? Anyone online? Aggravating, mitigating factors? Quite group online today.
I believe we only have SEC Olson online.
Oh, all right then. There's still a lot of names. If you can read, I'm gonna leave it in the estimation, if you can.
Right,
Let's see.
mitigating, I have that the investigation, was lacking, details in its totality. And we don't have quotes, for a number of the allegations. There were inferences without details. that we are guessing about domestic violence, and, there is information to allude to that, but there is no supporting information. It's common for officers to contact family on their work phones, and we don't know enough about the situation, but she did indicate that she wants him to keep his job. The girlfriend indicated that she was not afraid of being harmed, by Clark. She just wanted him to stop contacting her. And if the mindset from the agency was that what he was doing was criminal, they should have turned it over immediately to an agency for investigation. There was not enough information to say that she was calling, that he was calling from a phone number that she did not know when he was using his work phone. It was questionable whether an agency could interfere with a personal matter and base separation and investigation on a personal issue. The girlfriend indicated that it happened multiple times in the past, their breakup, and that she was not concerned for her safety. It was an interesting route for her to go to the agency instead of going through the court system, which is set up for these types of issues, but instead chose to contact his employer. And then for aggravating, agencies can get involved when there are allegations or concerns about domestic violence. His agency had a right to restrict in this situation because of what he was stalking. She purchased a car and a home without Clark knowing. If we remove concerns about domestic violence and just look at it as a stalking issue, we do have enough information on his behavior to meet the criteria for stalking. Victims don't have to participate in criminal investigations. The burden on the employer for their investigation is a preponderance of the evidence, which is just slightly over 50%. He had 30 years in law enforcement and knows what stalking is, and didn't appear that he could accept that his behaviors were over the line. He alluded that he did not know that what he was doing was wrong. He crossed the line when he used his police phone to contact her, which I think was perhaps taken back or changed in a mitigating. I think that was all I had written down. Please let me know though if I did not capture.
Thank you. We have a consensus on our identified aggravating and mitigating. Anything missing? Any objections? Okay, so we'll discuss whether or not there was a moral fitness violation. We need to either upper, modify, or maybe. And there are all three. Chair, now for the record, I'm inclined to make a motion to remove dishonesty and potentially misuse of authority because I don't have enough information, and authority misconduct because I do believe there was some level of misconduct because he had been told by his employer to stop and did not.
You're making a motion.
I don't know. Put it out there. Yeah, it's, you know, all right. Yes, it's a motion to, right. I feel like Tanisha Barrett has something to say.
Oh, no, I'm listening.
Okay.
I didn't hear, what's the exact motion?
I'm going to make a motion to affirm misconduct and negate, no, and we'll modify this to take out dishonesty and misuse of authority and affirm misconduct. Yes,
Second.
thank you.
All right, we are voting on a motion to modify the moral fitness violations to remove dishonesty and misuse of authority and affirm misconduct. Chair Nowling?
Aye.
Vice Chair Connie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend? And Committee Member Wood?
Aye.
Motion passed.
Okay, now we have to decide, do you want to take action or take no action? And if we take no action, we do include why no action is recommended. Take discussion, or motion to take action or not to take action.
Robert,
Would you like to-
can staff just remind us what the misconduct or permit would be in one of the comments?
I can, Captain Comfort with record misconduct is a 3 to 10 years. And the time frame, at least we got in the report, would be, June 15th of 2022.
Probably for the record, so if we take action, we cannot or we cannot approve a 0 year. We have to go minimum 3.
It's like watch with the record, you can. I'm sorry,
Well, you, but if you did a 3-year, it would be June 15th of this year would be the 3-year period. So essentially, it's almost times 6, correct? So it's close to 0, it's correct.
3 years.
Is the minimum.
But I believe in the past that we have decided to take action and then have 0 years of revocation. If I use.
I think it was affirmed to take no action.
Right.
Yeah.
So we could take no action if there's a motion to take no action, or we could take action and then discuss about the amount of time that we want to take.
Fair, for the record, can I just add one more little piece of discussion that I was sorting through, and because it would be aggravating to me. When he was interviewed about this, at one point he told his former girlfriend not to tell anybody about it. And when questioned about why he told her not to tell anybody about it, his mind was even tracking with the fact of, he thought that if the chief contacted Medford PD, or if there was a restraining order or a stalking order, that he could get in trouble. So he was even tracking that his behavior was leading that way, whether we have the supporting documentation or not. So if I'm gonna make a motion, it's gonna be that we do take action, but I could go towards the lower for it. The investigation aside, we have to make a decision based on what we have, that comment alone leads me to be like, no, I'm gonna take action.
Rest for the record, follow up on that. When he walked into that meeting, he asked if he was being fired. That initial meeting, so that would also go to what you just said, that you were sort of tracking on that line for that's how he walked into that first meeting when he was called.
So is that a motion to take action?
If nobody else wants to add to that, I would make a motion that we take action.
Livingston, second.
All right, we are voting on a motion to take action. Chair Nowling?
Aye.
Vice Chair Connie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend? And Committee Member Wood? Motion passed.
Yeah, I mean, for the record, we need to have discussion and motion regarding the amount of time that we already discussed. We're 3 to 10 years from
June 15th, 2022 would be the start date. So if you make a recommendation or a motion, just explain why you're asking for that amount of time.
Barry, I would make a motion, for 3 years. Because of the caliber of investigation coupled with statements from the female half of not fearing for her life, not fearing for safety, not wanting him to get in trouble, and things of that nature.
We are voting on a motion for a 3-year ineligibility period. Chair Nelly.
Aye.
Vice Chair Connie.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Daniel.
I,
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lawler. Committee Member Townsend. And Committee Member Wood.
Aye.
Motion passed.
Third one. Oh, yeah. Miss Jones. Finally. But everyone's at, Jeffrey Kylan. Let's see, you can go ahead.
Melissa Langbach for the record. Policy committee members, the department opened a professional standards case for Jeffrey Kenlin based on his termination from the Dallas Department. Kenlin's termination followed his placement on the Wasco County Attorney Tier 1 review list. The DA's office placed him on the list of conduct occurring in 2011, which they had not previously reviewed. The DA's office found by a preponderance of the evidence that Kenlin made false statements to his supervisor and fellow officer regarding the need to use a city vehicle and where he was staying during a training, which led to him violating the agency's policy for truthfulness. Kenlin used a vehicle under false pretenses and used the city's resources to travel between Eugene and Salem, which was part of that policy violation for truthfulness. Kenlin was untruthful and lacked